I see a bit of a tension in the way you've started arguing this case, because you've said many times the structural constitutional claims are special, different. There's a real need for this kind of review. And Thunder Basin, it's really a focus on what kind of claims they are. So Thunder Basin allows you to talk about that. But your statutory argument really does not allow you to talk about that, because there's nothing in these statutes that would treat structural constitutional claims any differently from any other claims, statutory claims, claims about just evidentiary rulings. So the way you want us to decide this case is going to have ramifications far beyond structural constitutional claims. And indeed, it's very hard on your interpretation of the statute to see why the nature of the claim would have any relevance at all.
So I guess first I would say we would be comfortable if this court followed the text of what Congress enacted and held that there was jurisdiction here and perhaps jurisdiction in other cases to be sorted out, applying the tools that district courts apply all the time, exhaustion, finality, and whatnot. But the second is, I guess I would disagree with the premise of Your Honor's question in the sense that structural constitutional claims are different in a way that's meaningful in the statute. For example, as to the relief that you could get in the Court of Appeals. This statute allows Court of Appeals to set aside or modify the final order. But in the structural constitutional claim, that doesn't give you the relief that you're looking for. It wouldn't give us the relief that we're looking for, because we're looking for an injunction against this unconstitutional agency action. And my friend, Mr. Stewart's answer on this question, I think, was telling. What he said in that situation is, well, you would get a decision, and on remand, maybe the case that comes out of the Ninth Circuit would have to follow that. Which is to say that the agency might not have to follow that with respect to cases in the other circuits. And we're talking about, again, about the very existence, the very authority of the decision maker to act at all, which is different.
So,
and the fact, sorry.
Keep going.
No, I was just going to say, the fact that the statute is limited in terms of the relief that the Court of Appeals can grant, actually, I think, does speak to why these claims were not divested by Congress.